Hello, I'm Brian Mayer. I'm an attorney practicing family law in Southern California, and today I'm going to be answering the question, how does a court decide whether to grant sole or joint legal custody over a minor child? Now, when I talk about custody, a lot of times people think of physical custody. Physical custody, it has to do with how a minor child spends his or her time. That is, with which parent is the child physically placed. And legal custody is different. Legal custody has to do with the decision-making power that affects a child's welfare. Now, this decision-making power can pertain to education decisions, where the child goes to school, what kind of classes they're enrolled in, whether they are religious-based classes or private schools, homeschool, those sorts of things. It pertains to medical decision-making, what kind of health care or medical procedures a child receives. It can pertain to psychiatric care, anything that affects the child's general welfare that is not controlled by the question of physical custody, that falls under the legal custody umbrella. Now, when we talk about sole legal custody, we're talking about a situation where one parent alone can make those, has the power to make those decisions. Whereas with joint legal custody, that's where both parents have a right to be heard. And oftentimes that means one parent has veto power over the other with regard to any sort of change to the status quo in terms of the care or education that the child is receiving. And a lot of times in contentious custody cases, legal custody can become a major issue because oftentimes the parents they don't trust each other, they lose perspective, and it's not uncommon to hear one parent complain that the other parent is deliberately sabotaging the welfare of the child or deliberately using their powers of legal custody to frustrate their ability to parent and do what's best for the child. So it can definitely be a big deal. And the first thing to understand about legal custody is that, generally speaking, there is a legal presumption and a preference for parents to have joint legal custody of their child. So for a normal circumstance, under normal conditions, even where one parent may have sole physical custody of the child, the general preference is that both parents still be allowed input as to decisions affecting the child's welfare, and joint legal custody is generally preferred. So anytime that you're looking to establish sole legal custody, understand that you're starting out from a legal disadvantage. The facts may be on your side, but the law it's an uphill battle dealing with the law. Now, if you're a parent who wants that joint legal custody, then I have great news for you. Unless there's an affirmative reason that we discuss here today, you can probably expect that you're going to be able to get joint legal custody of your child, even if the physical custody is something less than joint physical custody. So depending on what your wants are, depending on what the circumstances are, this may or may not be good news for you. But that's how it's structured. The courts say, okay, even if you're not necessarily there and you're not necessarily that closely bonded with the child, you're still the parent. You should still have a say in terms of decisions affecting that child's welfare. So you're starting off with that position going into it, that there should be joint legal custody. And so for a parent wanting sole legal custody and believing that that's best for the child, the first and foremost is that legal custody decisions ultimately are made based on the best interest of the child. So regardless of whether or not there is an affirmative reason that is discussed here, if the circumstances of your case are such that it's even if there's not one of the exceptions that I'm going to talk about, if the circumstances just call for it, because that's just how it is, that's just the personalities involved, and if the evidence can show it, then yes, the court can still grant you sole legal custody, because ultimately it is a question for the courts. It is a question of discretion for the courts, and the court, in its discretion, can award joint sole or joint legal custody based on its finding that that's just what's best for the child. But here are some of the things that the court will consider and will give heavy weight to in terms of its decision to grant sole legal custody. And first of all is whether there has been abuse or neglect of the child. So if you have a situation where, and I'm going to tell you right now, I'm going to make the dad the bad guy in this hypothetical. This doesn't mean that men are any more or less likely to be perpetrators of any sort of misconduct, but just for consistency, just to avoid confusion, in this strictly hypothetical scenario, Dad, we're making you the bad guy this time. No hard feelings, okay? So let's say that Dad is not a very functional human being. He loses his temper. When the child has been in his care, let's make it a young child. He doesn't feed his 2-year-old for just hours and hours on end. He falls asleep drunk on the couch while the 2-year-old is in the knife drawer playing with utensils. When Dad loses his temper, he has a tendency to spank the child just unnecessarily, too hard, so it leaves a mark. Any of those sorts of things. Let's make it even easier and say that CPS is involved. CPS investigated, found that Dad has been abusive or neglectful, and they've taken an action against him, and that finished up, and now it's in the family courts. If you have this sort of situation, the court you're probably going to have a pretty good argument in most cases for an award of sole legal custody to mom. Looking at the best interest, and it ultimately falls into that best interest standard, looking at the best interest of the child, when you have a parent who's demonstrated an unwillingness or inability to provide for that basic safe environment for the child, then the court's going to say, you can't provide, you've not demonstrated a willingness or an ability to keep the child safe, so when it comes to welfare decisions, we are not going to trust you with that at this time. So that is one common basis for an award of sole legal custody. Another one would be abandonment. This is where a parent through volitionally, intentionally, just ups and leaves and doesn't have contact, or has sporadic, inconsistent contact with a child over an extended period of time. Where you have that kind of absence, the court is going to be inclined to find that the custodial parent it's appropriate and in the best interest of the child for the custodial parent to have that sole legal custody. This does not apply to situations where there's been a temporary short-term absence. Maybe Dad he can't handle the stress of breaking up with mom, and he disappears for a month and then comes back and is ready to be a parent. It doesn't apply to a situation where Dad is in the military and he gets deployed overseas and he's gone for 18 months because he's on tour fighting in the Middle East. It doesn't apply to those sorts of situations where Dad basically is in a situation where it doesn't apply to those situations where Dad's absence is less than voluntary. Okay, this is where the parent has disappeared, and the court is going to look at that and basically say your inconsistent presence, your unwillingness to be a part of the child's life demonstrates that you're unable to continue with that joint custody a joint custody role. So we're going to give the legal custodial decisions over to the parent who has been present. In this case, in this hypothetical, it's mom. We're going to give mom the preference. We're going to give mom the joint legal simply because she's there, and we know, based on her history, she's going to continue to be there when those questions about the child's welfare come up. So, in abandonment or an absence, that is another basis for which that's another reason that a court will grant legal custody. Another one that comes up fairly often is where there's been domestic violence perpetrated against the other parent. Now, in California, where I practice, for example, it's actually written into the statutes that when there's been a finding of domestic violence from one parent against the other, the perpetrating parent is presumed to not be fit for legal custody for, it's a rebuttable presumption, but typically for 5 years after that domestic violence has been perpetrated. So this can be very serious. You may have a situation where during the marriage or during the relationship, one spouse was abusive to the other. In this case, we're pretending it's dad. Dad has hit mom a few times, pushed her around, said some terrible things, and they get out of the situation. Mom files for a restraining order against dad, and she gets it. And now there's a finding of domestic violence, but a consequence of that is that with that finding of domestic violence, the legal presumption is that mom should have sole legal custody. So even if the child wasn't present when it happened, even if the father or the parent has been a terrific parent to that child, has been present, has been active, has participated in their life, when one parent commits that domestic violence against the other, then it's presumed, at least in California, it's presumed that that parent should not have joint legal custody, that it should be an award of sole legal custody. Now, the laws vary somewhat by state, but every state, nonetheless, will still, to an extent, will recognize this, particularly if the child was present during any of the domestic violence. So when there's been domestic violence, that can absolutely be a deciding factor in terms of the award of sole legal custody to one parent over the other. Something else that can come up is when a parent has committed some sort of crime that reflects on their ability to be an effective parent for the child. So this would be the case where, for example, just to make it easy, where a parent has engaged in a crime of abuse against an elderly person or some sort of child abuse that doesn't relate to this child or these children, but nonetheless the court can say, okay, this shows a certain character and propensity to act in a way that's not in the best interest of the child. So based on the commission of these other crimes, based on these convictions, we nonetheless will find that sole legal custody would be appropriately awarded over to the parents who did not commit these crimes. So that sort of criminal, even though the perpetrating parent may have caused no harm to their child through the commission of these crimes, that absolutely can be a factor of consideration. Another one that interestingly can come up is where we have an instance of abduction. And this doesn't have to be a criminal conviction, but result in a criminal conviction. But let's say that mom and dad are living together and they have their child together, and we're going to keep with the story that dad's the bad guy in this hypothetical. The parents split up, and in his anger, dad takes their child, puts them in a car, and drives them to the other side of the country, 3,000 miles away, doesn't tell mom where the child is, and disappears for maybe 2 months while mom is going crazy, frantic, wondering if she'll ever see her child again. Dad is located, he comes back, The fact that this happens, there was this sort of abduction, that can absolutely be a basis for awarding sole legal custody to the non-offending parent, in this case mom. And what that also ties into is it also ties into the question of interference in the custodial relationship. And for a lot of people, this is where the desire for sole legal custody comes, is because they're experiencing interference from the other parents, and they want that sole legal custody simply because the other parent is not functional enough for them to be able to co-parent and seek what's best for the child. So when one parent is interfering, actively working to interfere between the parent-child relationship between the other parents and the child, that interference can be a basis for the award of sole legal custody. In California, where I practice, again, this is something that's actually codified. It's in the statute, and the statute says that the court shall consider the extent to which either parent has interfered with the relationship between the child and the other parents when making that legal custodial decision. So this would be the sort of situation where, let's say, you have, again, dad's going to be the bad guy. You have a situation where they have joint legal and physical custody, but dad is deliberately scheduling activities for the child during mom's time, putting mom in a situation where she either has to exercise her custodial rights or forfeit them so that her child can do the activity, the fun activity that dad wants to, that dad has set up. Dad is unenrolling the child from one school without permission and enrolling the child in another school. Dad is saying terrible things about mom and telling the child things like, well, if you loved me, you won't go see your mother's a terrible person, all she cares about is money and child support, these sorts of things. If it's pervasive enough, if it is persistent and offensive enough, then the court absolutely can strip that parent of legal custody and give it over to the other parent. And the reason being, quite simply, is that the court understands that, first of all, if you give that power to an abusive parent, they're simply going to use that power for abuse. Secondly, there needs to be some sort of balancing there, because if the abusive parent is going to be using their contact and their leverage to try to interfere with the relationship, then the non-offending parent has to be given some sort of ability to some sort of extra power just to be able to counteract that sort of interference. So that is something that can also come up. I'll be clear that proving that can be a little bit more difficult than some of the other issues. For example, if there's a criminal conviction, that's easy to prove. If the parent has moved out of the country without a word to go live on the high seas for 6 months or a year, that's usually easy enough to prove. When we're talking about this sort of little nitpicking, vindictive campaign of harassment and using the child relationship as their mechanism for inflicting that abuse, it can be a little bit more difficult to prove, but that's also why it's really helpful to get an attorney involved anytime you're looking for some sort of drastic change in a contentious family law case. An attorney can help you identify the evidence, can help make sure that the evidence is framed in the correct light, and also that the evidence is admissible and given to the court in a way that is influential and persuasive to the court. And as I said initially, all of this just really ties into that best interest of the child standard. With any case, these are certain things that you can present. Some of them are kind of automatic once it's been established, but in every case, it is discretionary to the court, and in every case, the court can apply its best interest of the child standard and its discretion to pretty much make whatever decision it wants, as long as it can articulate the basis behind that decision. So if you're looking for sole legal custody and one of these reasons does not apply to you, or maybe it does to an extent and the evidence is just kind of weak, don't necessarily give up. You may need to strengthen your case. You may want to strengthen your case. But if you're looking at your situation and just saying there's no way that this is good for my child, then you understand that the court can still consider the information and the facts as they are and make its order based on that. Likewise, if you want joint legal custody, and if one of these things that we discussed applies to you, maybe there was domestic violence, maybe there's been some sort of conviction, maybe there was an absence in the child's life, I don't know. If one of those things does apply, it doesn't mean that it's hopeless for you either. It just means that you're going to have to look at what evidence you have available to overcome those sorts of presumptions and assumptions, and explain to the court why it really is in your child's best interest to have that joint legal custody. So I hope this was helpful. Please subscribe to this group. I'll be posting more videos. Please feel free to contact my office if you're looking for consultation or representation, particularly in Southern California. And I definitely wish you well. Please also consider joining my Facebook group if you have Facebook, where there will be other questions of this nature and where you can ask your own questions and get some answers. Thank you.